Mr. Colville, Mr. Anslow, I don't want to discourage you from taking your usual note, but what I propose to do is that we should give our judgments orally, but they're in a condition where, in quite short order, within the next day or two, you should receive a hard copy of them, and it will be that hard copy that will be placed on the website in the normal way. And so rather than going through the process of transcripts and all the delay that involves and expense, you'll receive something in due course. Thank you very much. This is an appeal by Mark Gary Coates from the committal order made by Her Honour Judge Venn on the 26th of October 2023, by which he was sentenced to a term of committal amounting to 252 days in prison. The sentence was passed after the judge had found Mr. Coates to be in contempt of court as a result of 7 breaches of an order made on the 20th of September 2022. At the hearing before the judge, Mr. Coates was unrepresented. Before us, he is represented by Mr. Colville. The respondents, Miss Turner and Mr. Greenwood, have been represented at both hearings by Miss Anslow. We are grateful to Mr. Colville and Miss Anslow for their submissions today. The committal proceedings arise out of a civil claim involving Mr. Coates and his wife, the occupiers of number 9 Eatondon Lane, Robertsbridge, and the respondents who live at number 10 Eatondon Lane. A boundary dispute concerning the boundary between them was determined by the judge on the 20th of September 2022 after a 5-day trial. The respondents, who were the claimants, succeeded, and the judge made a series of orders in their favour. These included damages amounting to £260,000, costs on an indemnity basis, and a series of orders under the Protection from Harassment Act 1997. For our purposes, the relevant ones are. Then the text of the judgment will include paragraphs 8, 16, 17, 19 and 20. Mr. and Mrs. Coates sought permission to appeal, which was refused twice by Mr. Justice Mead, first on paper on the 12th of January 2023, and then at an oral hearing on the 27th of February 2023. They then applied for the decision to be reopened. This was refused by Mr. Justice Miles on the 19th of April 2023. A further attempt to take it to this court was refused by Lady Justice Asplin on the 11th of October. On the 10th of May 2023, the respondents made a contempt application, alleging that Mr. and Mrs. Coates had breached the orders recited above in some 24 respects. The application was initially brought against both Mr. and Mrs. Coates. The respondents subsequently indicated that they did not wish to pursue the application against the latter. The matter was listed for hearing on the 7th of July, but was adjourned before that date due to judicial unavailability. It was relisted on the 10th of August, but again was adjourned to the 22nd of September as Mr. Coates had only obtained legal aid on the 30th of July. That hearing was then adjourned by another judge until the 26th of October, because of apparent difficulty in finding counsel for Mr. Coates. On that occasion, Mr. Coates was directed to file any evidence he intended to rely on by the 19th of October. On the 24th of October, 2 days before the hearing, the solicitors applied to come off the record for lack of counsel. At the outset of the hearing on the 26th of October, Mr. Coates applied to the judge to recuse herself. She rightly refused, and there is no appeal from that decision. He then applied for a further adjournment to allow him time to seek legal representation. The judge refused that application on the basis that the proceedings had been on foot since May, and a fair opportunity to obtain representation had already been given. Again, there is no appeal from that decision. At the committal hearing on the 26th of October, the respondents relied upon a number of affidavits. Mr. Coates had signed 2 witness statements on the 2nd of September. They ran to 75 pages, including many exhibits. The respondent, Miss Turner, gave lengthy evidence under cross-examination by Mr. Coates. He chose not to give evidence himself and relied upon his witness statements, and he made closing submissions. The judge found that the respondents had proved beyond reasonable doubt 7 allegations of breach of the injunction. Those were allegations 1, 2, 7, 8, 9, 11 and 12. She found that he'd failed to remove various objects, that he'd threatened and filmed Miss Turner, threatened the respondents during the hearing before Mr. Justice Mead on the 27th of February, and that he'd thrown stones over the fence. She found that he still had cameras trained on the respondents' land. Having heard mitigation, the judge referred to this court's recent guidance on sentencing for contempt of court, as set in Lovett and Wigan Borough Council, citation given. In addition, she referred to the Civil Justice Council's report produced in July 2020 and approved in Lovett, entitled Antisocial Behaviour and the Civil Courts. She considered each breach to merit the following immediate sentence. 1, 28 days, 2, no order, 7, 84 days, 8, 28 days, 9, 168 days, 11, 28 days, and 12, 84 days. The judge then reduced the total figure of 420 days by 40% to produce a term of committal of 252 days, so approximately 8 months. On the 15th of November, Mr. Coates appealed. He now seeks the quashing of the contempt finding, alternatively a lesser sentence leading to his release. His grounds of appeal, expanded without opposition from the respondents, are these. 1, the sentence is manifestly excessive. 2, the judge, by failing to consider whether each sentence for the allegations proved should run concurrently as opposed to consecutively. 3, the judge failed to give any sufficient consideration as to why the sentence should not be suspended. 4, having dismissed Mr. Coates' application to adjourn the hearing to seek legal representation, thereby necessitating him to act as a litigant in person, and upon Mr. Coates electing not to give evidence during the hearing, the judge erred in considering and taking into account the witness statements prepared by his and his wife's previous solicitors that had been included in the trial bundle, and his closing submissions in determining whether the respondents had proved the allegations. In respect of the 9th allegation, the judge erred in, this is ground 5, the judge erred in concluding that the submissions made by the appellant at the hearing of his oral application for permission to appeal, heard by Mr. Justice Mead on the 27th of February 2023, were threatening behaviour in breach of paragraph 16 of the order dated 15th September 2022. Further, she erred in finding that this was, quote, a very serious breach to threaten to escalate matters and of very high culpability, warranting a sentence of 168 days in custody. I'll first consider grounds 4 and 5. On ground 4, Mr. Colville argues that a defendant has the right to remain silent and cannot be compelled to give evidence in a contempt application, CPR 81.7 sub 3 and 81.4 sub 2n. As Mr. Coates appeared as a litigant in person and chose not to give evidence, the witness statements prepared earlier ought to have been excluded from the proceedings. The judge erred by failing to do so and by taking those statements into account. We have considered Comet Products and Hawkex Plastics, citation given, Arley, Geedy and Smith on contempt, 5th edition, and Inri B, citation given, where Wall J held that the court does have the power to direct a respondent to committal proceedings to file and serve any affidavits or statements on which they might wish to rely. However, he went on to say this about the respondent who does not wish to deploy the evidence thus filed. In my judgment, the correct approach is that adopted by Sir Stephen Brown, President, in Re W, Ward's Publication of Information, citation given. The applicant can make no use of the respondent's evidence until it is deployed by the respondent, either by reading it or relying upon it. It equally follows that a respondent who obeys the direction to swear, file and serve affidavit evidence prior to the hearing does not, by so doing, put himself in peril of cross-examination until such time as he deploys the evidence in support of his own case. The respondent to a committal summons is thus in no way prejudiced by obeying a direction of the court for the filing of evidence. On the other hand, the filing of such evidence enables the case on both sides to be properly prepared and unnecessary adjournments avoided. We heard interesting submissions about the correct interpretation of what had happened in the present case. At the beginning of the hearing, the judge carefully warned Mr. Coates that he did not have to give evidence and that he was at liberty to withdraw his statements if he wished. Mr. Coates then cross-examined Miss Turner extensively, with frequent reference to exhibits to his statements. However, when it came to the point where Mr. Coates might have given evidence himself, he declined to do so, but said that he relied upon the contents of his statements. Before us, the parties were not unanimous as to whether this was a proper course. Mr. Colville submitted that the contents of the statements did not become evidence, as they had not been verified from the witness box. Miss Anslow submitted that by virtue of their use in cross-examination and the express reliance placed upon them by Mr. Coates, they became evidence that had been, quote, deployed in the manner envisaged in Re B. We mention this issue because it may arise in future, though not, we suspect, very often. Where it does arise, the court will need to take care to ensure that findings of contempt are only based upon evidence that can properly be relied upon. It is unnecessary to say any more on this appeal, however, because in fact the judge did not place any significant reliance on anything that appeared in Mr. Coates's statements. She referred to him as having made an admission in relation only to the first and second breaches, which related to the presence of objects on the land. Those breaches were proved beyond doubt by the evidence of Miss Turner and by photographs. Nothing that Mr. Coates said was necessary to those findings of breach. There is nothing remotely approaching a serious procedural error leading to injustice. This ground fails. Ground 5 arises from the permission hearing before Miss Justice Mead. In the course of lengthy submissions, Mr. Coates said this, and I then quote the passage. Miss Turner, who was present in court, understood this to be a threat of physical violence towards her or her partner, or criminal damage to their property. However, no one intervened, and the hearing continued. The judge found, paragraph 72, Mr. Coates laughed when it was suggested that this is a clear threat in his own words in front of a judge, but it is difficult to see what he could possibly have meant if it were not a threat. Inaudible words, a criminal charge, a criminal matter. He declined the opportunity to explain his comments and evidence and to explain what else he could possibly have meant, and I'm satisfied beyond all reasonable doubt that he did say these words and meant them as a threat. That is a breach of paragraph 16 of the order. The reference to a laugh may have been to Mr. Coates's reaction to Miss Anslow's closing submission about this allegation. It said on behalf of Mr. Coates that these were not threats to the respondent, nor, if they were, could they be treated as being of very high culpability. For the respondents, it said that this is a finding of fact with which this court should be slow to interfere. The principles set out in Volpe and Volpe, reference given, are relied upon in support of the contention that the judge's conclusion was rationally insupportable. I've underlined the only part of paragraph 16 that might be relevant. I then set out the paragraph and underlined the words or otherwise intimidate or harass the claimants. I acknowledge the field that the judge had for this case. However, even if the order was wide enough to cover remarks made in a courtroom, it is, in my view, stretching the effect of the injunction too far to treat this as a separate breach of the order. It was certainly yet another clear manifestation of Mr. Coates's disobedient and unapologetic attitude, which is understandably distressing to the respondents. but the words themselves are not unambiguous, and the context in which they were spoken was unusual. It is not possible to see how the judge came to make this finding to the criminal standard without further explanation. I do not consider that it can be rationally supported as it stands. The words do not expressly threaten an attack on the respondents or their property, and might also be read as indicating a threat to resist, possibly with force, any attempt at eviction. If I'm wrong, it was a clear error to treat this statement as if it was by some distance the most serious of the breaches, attracting a sentence of 24 weeks imprisonment. I doubt if any custodial sentence was warranted, but if it was, it would have been at a low level. Next, ground 2. This is that the judge erred by failing to consider whether the sentences should run concurrently as opposed to consecutively. Mr. Colville submits that the judge was bound to consider whether the sentences for each breach should run concurrently. Further, the decision to impose consecutive sentences produced a custodial term that was unreasonable and disproportionate. The respondents highlight that the judge clearly considered the ability to order a concurrent sentence and argue that her judgment was alive to the totality principle. This is reflected in the fact that she reduced the overall sentence by 40%, thereby rendering the sentence proportionate to the overall conduct. In effect, the complaint in this case was about a course of conduct, and the judge might have treated it as such. However, in Lovett and Wigan Borough Council, reference given, this court stated that it's good practice to consider a penalty for each breach found proved, and the terms of imprisonment may be concurrent or consecutive to each other. The guidance given in Lovett is in the following terms. When considering the correctness of a decision to commit a defendant to prison for contempt of court, the 5 options available on sentencing are these: an immediate order for committal to prison, a suspended order for committal to prison with conditions attached, adjoining consideration of the sentence, a fine or no order. A custodial sentence should be reserved for the most serious breaches and for less serious cases where other methods of securing compliance with the order have failed. A penalty for each breach proved, and the terms of imprisonment may be concurrent or consecutive. Simply adding up what may well be appropriate penalties for each individual breach is likely to lead to an excessive sentence. The 3 levels of culpability are, I set them out. The 3 levels of harm are, and I then set them out. I then refer to the Civil Justice Council's table in relation to antisocial behaviour in the civil courts. In this case, the judge assessed the breaches in the following way: 1 and 2, no bracket; 7A2, 8B2, 9A1, 11B2, and 12A2. I'll turn in passing to ground 3, which asserts that the judge should have passed a suspended sentence. I would accept that some judges faced with these contempts might have done so in the hope that compliance could be achieved. However, in this case, Mr. Coates showed no appetite for compliance, and I do not consider that the judge can be criticised for passing an immediate custodial sentence. Centrally, Mr. Colville argues that the sentence was manifestly excessive, as the appellant was acting in person, he had difficulty in representing himself, there was no consideration of the fact that he'd been ordered to pay the sum of £260,000 plus interest, in excess of £400,000 at the date of committal, which was sufficient punishment as it would require him to sell his home. Mr. Coates and his wife care for their dependent adult son who has moderate autism with severe social and communication difficulties, and his time in custody would impact on the family. Mr. Coates was a man with a clean record, and his time in prison had been a salutary experience which he does not wish to repeat. In my view, these arguments have little attraction. The fact that Mr. Coates was unrepresented is not a factor bearing on sentence. The fact that he'd been ordered to pay, but has not paid, damages and costs is entirely his own fault, and is a separate matter from the contempts with which the judge was dealing. His personal circumstances were known to the judge, but more particularly they were known to him when he embarked on his contemptuous behaviour. Finally, we've heard nothing to suggest that Mr. Coates has altered his attitude, so I'm not impressed by the particular arguments in mitigation. Far more persuasive is the broad submission that the sentence imposed was excessive. Mr. Colville argues that each breach, rather than bearing the weighting chosen by the judge, should have counted as falling within C2 of the table, minor breaches with medium culpability, so attracting a starting point of adjournment and a range of up to 1 month. He also argues that the judge insufficiently explained why the sentence should not have been suspended. I've dealt with that above. The respondents replied that the judge considered all these matters carefully and reached a proper sentence. The Civil Justice Council's guidelines are not a straitjacket, and judges have a considerable discretion as to how they should categorise breaches. But even so, I agree that it is not possible to categorise 3 of these breaches as falling within culpability category A, that is, high and of very serious effect. The words said by Mr. Coates to Mr. Justice Mead at the permission hearing cannot be considered to have been, quote, a very serious breach, if indeed they were a breach at all. The other breaches might at the highest be regarded as falling in category B. The upshot is that the starting point for sentencing for the individual breaches would be 1 month, with a range from adjournment to 3 months. In Lovett, at paragraph 39, the objectives in sentencing for civil contempt are stated to be, quote, in this order: 1, ensuring future compliance; 2, punishment; and 3, rehabilitation. I agree with the judge when she said that Mr. Coates's refusal to accept the order and the repetition of breaches were aggravating factors. Even so, looking at the matter overall, an immediate custodial term of 252 days, that is about 8 months, is markedly outside the range of proportionate disposals for a first committal term for breaches of this nature. Even if one deletes breach 9, that only reduces the term to 151 days, or about 5 months. Finally, ground 2 concerns the question of whether the judge should have passed consecutive sentences. This is not a straightforward matter. Lovett makes clear at 43 that it's good practice to consider a penalty for each breach found proved, and that terms of imprisonment may be concurrent or consecutive to each other. In the present case, the judge added up all the breaches and then applied a 40% discount. Mr. Colville submits that she did not sufficiently consider passing a concurrent sentence in a case where all the breaches were different facets of the same dispute. He accepts that the judge had a discretion, but she did not explain why she was making the sentences consecutive. Miss Anslow points out that the judge did direct herself by reference to Lovett. There are different routes by which, when a term of committal is unavoidable, an appropriate level of sentence can be determined. Had the judge characterised the individual sentences in a way that was more closely aligned with the Civil Justice Council guidelines, her approach of aggregating the terms and then applying a proportionality or totality check could not be criticised. She might also have decided to make some terms concurrent, for example, by grouping breaches involving failure to move items together and doing the same for breaches involving harassment. But if the starting points are too high, there is the danger referred to in Lovett of an excessive outcome, even if a discount is then applied. Alternatively, the judge could have sentenced by reference to the overall course of conduct with which she was faced. It was, in my view, a case in which a decision to sentence to consecutive terms required some explanation. In conclusion, therefore, I would uphold the judge's careful findings of contempt, except with regard to breach 9. Looked at in the round, these were contemptuous breaches of a clear court order, and they could not be ignored. As to sentence, I reject the argument that an immediate custodial sentence was wrong in principle. However, I would allow the appeal on the basis that the overall sentence was manifestly excessive. In the circumstances, a sentence of about 3 months' imprisonment could not have been the subject of a successful appeal. In fact, Mr. Coates has now served 47 days imprisonment. That is the equivalent of a sentence of 94 days, which is approximately 3 months. In the circumstances, I would substitute a sentence that allows for Mr. Coates's immediate release. Although the appeal succeeds to that extent, it need hardly be said that any further breaches of the judge's orders would be likely, if they were proved, to lead to more substantial terms of committal.
I agree.
I also agree.
Now, Mr. Colville, are there any other matters?
My Lord, yes, in relation to costs of the appeal, the appeal has been successful and resisted. I've asked that there be an order for costs in the appellant's favour.
Ms. Hansford?
My Lords, whilst I accept the appeal has been successful on some grounds, it has been substantially unsuccessful on other grounds. So I would say in circumstances the appropriate order be no order as to costs.
Crystal, you come round. There'll be no order for costs.
So for detailed assessment for the...
Of course, yes. And can I say, Mr. Colville, the judgments will be tidied up before they're handed down. We've obviously wanted to make sure that the parties had the outcome.
Thank you very much
in real time.
The time of court to deal with the matter today. In relation to the order requiring immediate release, that can be tidied up in respect of the necessary order that needs to
Yes, well, please speak to my clerk about how that order is to be drawn up. I don't imagine that it's going to be actually effected today.
No.
Bearing in mind that it's now 4 o'clock. But as soon as the order can be drawn in this court, yes. You'll want to know how it can be effectively received and transmitted.
Indeed. Great. Thank you very much.
Is there anything else?
No, my Lord.
Thank you both very much.
Thank you. Call round.